And good morning, everyone. Welcome to Talk Back. Welcome.
Yes, I'm John. This is Lawrence.
Oh, hi. Hi. Actually, Lawrence, this is Peter Christian. We've got you live on the air. Good morning, sir.
Good morning. How are you?
Wonderful. So glad that you could be with us this morning. We deeply appreciate it. And I just want to say, first of all, could you tell us where you're at right now, Lawrence?
I am in New York City right now, in my office.
Terrific. All right.
Now, you might remember Lawrence's name. We actually spoke to him a couple months ago as they were preparing to bring a lawsuit. And I guess I was going to talk to you, play catch up on what happened to that, and go into some of the details, because the last time we had you on here, we didn't talk about Turkey, and we didn't talk about all the other stuff that was implicated in this lawsuit. So I was hoping you could give us a little background on what happened after you brought the lawsuit, or tried to.
Okay, well, we had brought a lawsuit in the federal courts in the District of Columbia, Washington, D.C., to challenge the transfer by Northwestern Energy of the Kurd Dam assets and the property, the infrastructure and the property to the Confederated Salish and Kootenai tribes, which was an historic first for this country. And considering the size of the dam, its designation as a Category 3 hazard black start dam, which starts up on its own due to its hydroelectric capabilities in the event the grid went down, considering also the relationship the tribe had, among other Native American tribes, with a foreign government from the Middle East, that this was a problem. There were regulatory problems as well. The Federal Energy Regulatory Commission, and behind it, but unknown to the citizens of Montana, the U.S. Department of Interior and its Bureau of Indian Affairs and its Fish and Wildlife Service had really manipulated the terms of the license, changed them dramatically, added double the number of articles over the course of the 1990s without any public hearings. So people were not aware of how the basic operation of the license had changed dramatically in favor of fish, wildlife, and the environment. And I surmise that Northwestern Energy, is part of getting 12 other dams in Montana through its extensive lobbying, they were happy to rid themselves of the Kurd Dam and all of the political implications surrounding it. So we challenged that, and we raised issues concerning the government of Turkey's involvement with the tribes and with a number of other Native American tribes located around the country. And its selection of these tribes, there were 17 of them that went to Istanbul, Turkey in 2010, November. And those of you who have been following our lawsuit are aware that this was rather peculiar, given the fact that there are 566 federally recognized tribes, 326 of which have their own reservations. Why did they pick 17 to take to Turkey? Well, we found out doing research in preparation for the lawsuit that there was efforts by the Turkish government to lobby Congress to allow for Turkish enterprises to lease Native American reservation lands and buildings in an expedited fashion. That means they didn't have to follow ordinary Bureau of Indian Affairs regulations, which tend to be cumbersome and can delay transactions, or have been known to delay transactions for up to 2 years, given the inefficiencies of the Bureau of Indian Affairs. So Turkey had this goal out there to introduce, to have Congressman Cole from Oklahoma to introduce legislation that would have benefited primarily Turkish enterprises and would have allowed leasing of lands and buildings on reservations for up to 75 years if the tribal council's land lease regulations were approved of in advance. There was another bill called the Hearth Act, which deals with Indian housing and urban development, and that was introduced by Congressman Heinrich out of New Mexico. It was a parallel bill which almost said precisely the same thing and provided for precisely the same benefits, but for the fact that it was opened up to all the 566 tribes or 326 reservations, not limited to Turkey. But the bottom line is, in each of these cases, foreign entities could lease lands and buildings on Native American reservations for up to 75 years for business, agricultural, educational, cultural, and religious purposes.
Mr.
Passed
Kogan,
in 2012.
Mr. Kogan, we have to go to a break. While we do, I want you to think about this question and answer it on the back side. It's a question from Facebook. It's from Jay. Jay asks me to ask Mr. Kogan why a New York lawyer without reserve water rights experience is sticking his nose into the CSKT water compact. Who was the first person to ask him to do this? So that's the question.
Okay, well, we'll have that.
We'll get back to it after the break.
721-1290. By the way, are we sharing the PDF of the lawsuit?
Oh yeah, I'll post it on the.
Please
well,
do.
It's not the lawsuit; it's the paper. That
the paper, right? And because the things that are in this paper absolutely made my jaw drop, because the way I see it, and Lawrence will talk with you after the break, is that this Kerr Dam is quite literally a sleeping giant that could be, if half the things that are true that he writes in here come about, that a foreign power, especially that is not friendly to the United States, could have access to this kind of utility. Anyway, one of our callers or one of our Facebook posters asked the question, why is a New York lawyer, quote, sticking his nose, end quote, into the water rights compact here in rural Montana?
Well, that's a good question. Yeah, I may hearken from the People's Republic of New York City, but I'm not a communist.
Okay.
Unlike the tribe, which has its communal way of life and communal laws that are distinct from the U.S. laws, no, I was asked to come in back in the beginning of 2015 because of the water compact going through the legislature, and how people felt that they weren't getting all the information, notwithstanding the fact that there are many, many blogs out there that talk endlessly in beautiful terms about Federal Reserve water rights by experts who formerly worked for the Clinton administration. Yes, those people are in Montana. There's a Weiss Foundation, there's a Land Conservation Fund up there, and each of those organizations are staffed by former Clinton cabinet members and attorneys that go out there posing as anglers and fish and hunters that try to preserve the land for their sport, but they actually try to buy up ranches and farms and put them into Federal Reserve status.
One
so
of
there
the
are lots
questions
of things going on.
One of the other questions that was in that was, who invited you or who first contacted you on this issue?
Well, a former gubernatorial candidate in your state invited me out, Mr. Robert Fanning, who I must say is somebody who is rather wise, and he understands a lot of things. He understands connections, and I met him a number of years ago when I was out speaking in the West concerning property rights issues, because when you look at regulations and you look at federal overreach, you ultimately get to the issue of property rights. And my international background and ability to stop things from happening was one of the reasons, I guess the primary reason why they asked me out here. The Water Compact went through the legislature, notwithstanding the fact that you have all these technical abstracts, for example, that have most to do with where the reserve water rights are, and most of the legislators either did not read them or did not understand them. And the compact's terms themselves state that if there is a conflict between the terms of the compact and the water abstracts, guess what? The water abstracts govern.
All right. Tell you what, Lawrence, if you don't mind, I've got part of your paper up in front of me, and may I just read a little bit of it, because I'd really like you to comment on it.
Please, because this paper, as you know, or you may not know, has now been accepted for publication as a law review article.
Right. Okay. So this is article number 7, and it's in bold type. It says, new information strongly suggests that lack of federal oversight of sovereign, and that's in quotes, sovereign Native American reservations, including Montana's Flathead Indian Reservation, renders them vulnerable to Mexican drug cartel and Islamic terrorist use as, quote, forward operating bases, end quote. Would you, now to the average Montanan, just, putting their feet up, they drive through the Flathead Reservation all the time to get up to Flathead Lake and to go picnicking or on the way to Glacier Park. Probably never even, because, the Kerr Dam is off the beaten path. You have to travel some, windy roads to get there. And they don't even think about the Kerr Dam, which is no longer called the Kerr Dam, by the way.
Yeah, but I can't pronounce the new name, so I like referring to it as the Kerr Dam.
Exactly. So about this Article 7, Tell me where that came from.
That came from a lot of hard research, essentially showing that, actually personal experience. I was up at Hungry Horse Dam this past summer, and there was no security. Okay, there are people that have told me that they've been to Kerr Dam. There's no security. There's lots of information out there which now shows that has been provided by the FBI that you have members of ISIS that are in all 50 U.S. states. There's other information that was submitted as evidence in a federal court case several years ago that shows that Muslim Brotherhood is influencing not only Turkish policy but United States policy, and that they have organizations within the United States with which they are affiliated that are present among us, but we may not know where they are. And if you have a reservation because of the federal Indian policy that is not accountable to the state or to local residents because they are sovereign nations, dependent sovereign nations, dependent on the congressional fisc and ultimately U.S. taxpayer money, they don't, due to their sovereignty, have to report to anybody. There's nobody watching the store.
Okay, we do have a... Go ahead, Bob. John.
Aren't things pretty much, as far as security, the same as they were yesterday? I mean, before CSKT took possession?
Well, this is interesting because you had a private utility company, a public company that owned the dam infrastructure and lands, part of the lands on which the dam sits. The other part of the lands are Federal Reserve lands owned by the federal government. The dam was conveyed on paper to the tribe, but the tribe conveyed it back to the federal government to hold it in beneficial trust for the tribe. That way, they don't pay any state taxes. Montana statutes provide an exemption from state income tax, so the tribe doesn't have to pay any state income tax. The Internal Revenue Service provides an exemption from federal income tax, so the tribe doesn't pay anything. Now, the interesting thing is they got the dam. They bought the dam at a bargain sale price. I think it was $18.9 million, gentlemen, somewhere in that area.
Okay.
Well, while Northwestern Energy held the dam and was the primary licensor or licensee of the dam, they were making annual payments to lease the tribal portion of the land on which the dam sat each year. The license, which dates back to 1985, started that license or that leasing rate at a price of $9 million. By the time 2014, 2015 came by, the price had gone up to $19.2 million. So think of it this way. Northwestern Energy writes a check to the tribe for $19.2 million. The tribe deposits it and then pays $18.9 million to Northwestern Energy to get the dam back. Or they just have offsetting bookkeeping.
However, Lawrence, at that point, payments to the tribe cease from Northwestern Energy because now they own the dam.
Because they're no longer a licensee. They don't operate it. Now the tribe is the primary operator, and Energy Keepers, Inc. is the co-licensee. Now, the interesting thing is when FERC decided to grant it co-licensee status, it also granted it exemptions from the regulations of FERC. Part 2 of the Federal Power Act. They granted exemptions from. They granted exemptions from the Public Utility Holding Company Act. Reporting exemptions. Accountability exemptions. Dam acquisition exceptions. The public interest analysis that is normally undertaken for private licensees that acquire dams wasn't undertaken here. Because you know why? Ultimately, the federal government's backing everything up.
Right now we have callers. Bobby, you are on with Mr. Kogan. Go ahead.
Yes, thank you. This is concerned with the water compact. It's not directly related to the Kerr Dam, but I think all of it relates. Anyway, I received a short while ago a letter from the DNRC saying the first decree had gone through water court concerning all water rights in the Bitterroot River drainage subbasin and east side. It said even including, for example, wells for domestic or livestock use. And it also referred to anything that was put in, it was legal speak, so I don't really understand it, They've used the word abstract in almost every sentence, and they refer to your 1973, and if you dispute any of the new claims to water rights, that you had to have your complaint filed before June. I've talked to some of my neighbors. Everybody who's a landowner here has received it. They said they sent out 1,800 notices, though my husband and I both received separate notices. Can you speak on any of that? I'm having a lot of trouble finding out about it. However, I did go on the Internet, and I saw that, well, the word tribes is used in it, and also it says that the tribes now own SWP. And I'll take your answer off the air. Thank you.
Thanks for the call. So, anything familiar there, Lawrence? What Bobby had to say?
We were always arguing, even going back to August. Okay, that landowners and water rights holders should be filing their claims as soon as possible. Even though under the Chiotti decision of 1997, the Montana Water Court would hold in abeyance an adjudication of the rights until the Water Compact was ratified, until the Federal Reserve rights of the tribes were confirmed. But people may have, not done this because they were unaware of the need to do it. There aren't many people out there helping the irrigators, which is another reason why people had asked me to come out there. The so-called experts in Federal Reserve water rights were talking up a great storm, writing beautiful blogs, but not doing anything. And I'm sure they'll be angry by me saying this, but the facts are the facts. You should be filing your water claims because the court's got to know that there's other rights that are in contention. They can't. The court needs to know that it's not only the tribes that have water rights. That's the whole point of the water court adjudication, is to fight it out in court so you don't do something silly outside of court. And yeah, there are claims that unless you file back in the 70s, you're out of luck. And again, that is something that can be litigated because there has been really poor notice here. This state is not exactly very transparent. You have a Democratic governor who's in lockstep with the Obama administration and was and is pro-tribe and pro-environment and anti-irrigator. And then you have an attorney general who poses as a Republican who's not. And he signed off on a compact, didn't let anybody see his opinion, and walks away and says, I've done my job. Now, out east, we'd can him, let alone we'd skewer him on a barbecue. You all are just letting him get away with it, and you stop at this particular point.
Okay, well, let's get another call in. Bruce, you are on with Lawrence Kogan. Go ahead, Bruce.
Good morning, guys. Great show again, and it seems like turkey's rearing its ugly head. Mr. Kogan, I seem to remember, I don't know, maybe 6 months ago or something, there was some information released on this issue, and one of the concerns was Turkey's access to tribal mineral rights concerning yellow cake, which is uranium.
Okay.
And
that's a confusion. Okay. We found clear evidence of uranium mines and deposits around and outside the perimeter of the reservation. We didn't find anything on the reservation. Okay, Turkey. The CSKT was among 14 tribes located throughout the United States that had reservations within 100 miles of a nuclear power plant, a nuclear fuel facility, or uranium mines or deposits. If anyone has said that we've said that there was minerals under the reservation, we never made that claim. That may have been a misinterpretation. But the fact is that this tribe has special contracts with the Department of Defense to clean up uranium spills on U.S. Air Force bases. It has specific contracts with the Department of Defense to manufacture and supply replacement parts for foreign as well as the U.S. Air Force. And 3 of those foreign air forces include Saudi Arabian Air Force, the Libyan Air Force, and the Turkish Air Force. Thirdly, we found, after we filed the lawsuit, actually it was within, I think, a month of our filing, or actually within a few days of our filing, we found that the tribe was given a unique contract to provide software services for the Savannah Nuclear Weapons Facility in Savannah, Georgia. Now, considering that there are 566 federally recognized tribes, 326 of which have reservations, why did the government of Turkey pick 14 tribes, one of which was the CSKT, and why was Turkey in your state capital last April?
All right, interesting. We're going to come right back and continue that line of thought. Elaine is waiting to visit with you. We also have a line open. Lawrence Kogan is joining us from New York City, talking about the Kerr Dam and a lot of the things going along with that you may never even have entered into your imagination.
And I would like Lawrence to answer that question. What do you think, Lawrence? What do you think Turkey was involved in this scheme for? Are they trying to build a nuclear weapon through the tribes? I'm personally finding this a little hard to swallow. I think it would be easier to try to go to another country besides the United States if you're going to try to build a nuclear weapon, which we don't want you to build. But go ahead.
Actually, let me backstep on that. Okay.
Okay.
First of all, the U.S. has a 1-2-3, what they call nuclear civilian cooperation agreement with Turkey. It was entered into. It was negotiated by the Clinton administration. Shortly after it was signed, the ink was signed before it even dried. The Turks were caught cheating with the government of Pakistan and Pakistani sources. So they did not ratify that 1-2-3 agreement at the end of the Clinton administration. It took until the last year, the Bush administration in 2008, for the Bush administration to feel comfortable enough that agreement Turkey had complied with its terms. And it was only in 2008 that agreement went live. Turkey has made a public statement to the effect that it agrees with Iran that they each have an inalienable right to go through and do extra processing and enrichment of nuclear fissile material. It's their natural right as a nation to do that. That's contrary to what that agreement provides. Turkey will do what it wants, and because Turkey, there was just a recent merger in the United States with a Colorado-based company that acquired an Australian company that has extensive uranium exploration rights in Turkey in a major area. And that U.S. company has extensive uranium mining rights in the state of New Mexico. It has a uranium processing plant in Texas, which it moved to Turkey so it can process into yellow cake uranium. Now, why would the U.S. government approve that if it wasn't helping Turkey? It did it because Australia is an ally and it could easily pass muster under CFIUS review under the federal government of foreign investment or U.S. investment in foreign entities. Okay, so Turkey does want access to uranium. Now, the problem we have is that we import most of our uranium from the country of Russia. Now, that's not a real good strategic place to be in, but we have environmentalist crazies, many of them in Montana, that want to keep everything in a utopian state of preservation. Therefore, they don't like nukes. So we can't even increase and enhance our technology to reprocess the nuclear materials that come out of our naval vessels or our civilian nuclear plants in an adequate way, which our government could use as leverage against all the new nations in the Middle East that want to enter into these nuclear cooperation agreements. There are a number of countries in the Middle East that want civilian nuclear power, and the only way our country has been able to deal with them is by imposing leverage, by saying, you sent us your spent nuclear fuel and we'll reprocess it for you and sell you more. Okay, we can't do that if we're importing all of our uranium from Russia. But the anti-nuke people won't allow nuclear power plants to be built in this country. I think only one has been built in the last 35 years.
Okay, tell you what, we got to get some more calls. Everybody wants to visit with you. So Elaine has been waiting a long time. Elaine, you're on with Lawrence Kogan. Go ahead.
Thank you. Certainly the Turkish and Middle Eastern countries' involvement with Native American reservations on their private trust land is a concern regarding uranium and minerals. But I would like, there is one more piece. Setting up a Native American tribalism to integrate and engage with Middle Eastern tribalism also brings the opportunity for setting up little ISIS Sharia enclaves on private Indian trust land. That's as big a concern as the minerals we're discussing. But my question for Mr. Kogan is, I would ask him to please talk about the complete, even before the compact is ratified, the conditions on the ground today on this reservation is the complete federal monopoly of 100% control of access to all water, access to all electricity. We have a complete federal monopoly here.
Right.
Okay.
Elaine, that's a very valid and excellent point you make, which is why ultimately we will file another lawsuit against the federal government. that addresses that precise point. The dam transfer was the final piece of the puzzle, which was a multi-step process over the years for the federal government to regain total control over the reservation and its natural resources and its infrastructure. Okay, you have Mission Valley Power, which is owned by the federal government, by the Bureau of Indian Affairs, and it's operated by the tribes. That delivers electricity to the citizens, residents of the reservation, both private, business, and municipal. You then have the Bureau of Indian Affairs, which was essentially given control back over the Flathead Irrigation Project by the Flathead Joint Board of Control back in 2013 under the advice of the same Federal Reserve water expert that has wonderful blogs but has not undertaken any actions.
Okay, well, tell you what.
Then you have the dam that's now owned by the federal government in trust for the tribes. So the feds have a complete de facto monopoly and legal monopoly, really, over all the infrastructure and the natural water resources.
On the phone, the gentleman that you referenced a little while ago, Lawrence, Bob Fanning. Good morning, Bob.
Good morning, ladies and gentlemen, and thank you for taking the call. I would like to put to rest once and for all this typical Montana line, he ain't from here.
Okay.
So, we had a series of Montana lawyers who have committed legal malpractice, 20 or 30 of them to be specific, and when I testified on April 11th in front of the House Judiciary Committee, I pointed out that if they don't kill this phony compact, this contract that was forced down the people of Montana's throats under duress, that I was going to bring in Larry Kogan and a team to get to the bottom of it and sue. I promised them that they would be sued if they did pass this compact. In the House Judiciary Committee, we, Larry, myself, Elaine, the people on this side of the issue, we won 11-10. Montana rules prohibit bringing this in front of the full legislature once it's killed in the House Judiciary Committee. The rules were gamed. This transaction, this $900 million transfer of dams, the federal government hiding behind Indian law to pull their nefarious deeds and monetize water and steal private property that was granted to the people of Montana by act of Congress 100 years ago. All of these nefarious deeds, you can look directly at the gaming of the rules. They changed the rules of the Montana legislature in order to cram this transaction down the people of the state of Montana. This transaction is up to his eyeballs in corruption, and thank God that a New York lawyer would come here to straighten it out. And who invited him? I did, with money out of my own pocket as a senior citizen. I paid for Larry and this team to come and meet the people of Montana last April 21st. So the legislature has filthy hands by changing the rules in order to cram this contract down the throat of the people of Montana and steal their private property, the water that they own by an act of Congress. If an act of Congress gave the people of Montana this water, then it belongs to them, and you can't game the rules by buying off freshman rhinos out of Great Falls.
Okay, Bob.
This is corrupt.
Thanks for your call, Bob.
Thanks for the call. Thanks for calling in.
Yeah, you have anything to respond to that with, Lawrence?
I think he makes a valid point. The rules were gamed, and there was an agenda here. The large agenda is that Montana's got incredible natural resource. Okay, the feds want to control that natural resource, and the state is going along with it because they're getting paid off by the feds. Okay, there's all types of ways in which the federal government provides incentives to states for purposes of their cooperation. And this is one such scenario. You've got two dams, Hungry Horse and Kerr, that provide a lot of water throughout the Columbia River Basin and also provide a lot of electric throughout the electric system of that basin. The water can be used and be sold to other states for purposes of reallocation because they're in dire need of water. There's multiple reasons here, as well as the minerals involved that the feds want control over in that general area. And they use federal Indian policy as a cover to promote environmental values that are progressive and that are very, very liberal and extensively intrusive of private property rights. That's a fact. Okay, the tribe has several levels of jurisdiction, okay, which messes things up pretty much because it confuses the courts. You got at one level, you have federal, they treat tribal, federally recognized tribes as states for purposes of regulatory jurisdiction over the Clean Air Act, the Clean Water Act, and the Safe Drinking Water Act. They treat states as a municipal government for purposes of the Homeland Security Act of 2002. And now for FERC, which occurred with these dam proceedings, they treated the tribe and its Energy Keepers, Inc. as a federal instrumentality. That means as an extension of the federal government. So the federal government basically treats the tribe in any which way it wishes to achieve its desired policy goal and objectives.
Okay, and
that drives the courts crazy. It's the reason why Clarence Thomas, in a decision several years ago, called the federal Indian policy schizophrenic.
Question, and then I'm done. But the question is this. It's one that I think a lot of people are going to be feeling, especially members of CSKT. I have friends in the office. I play basketball with members of the tribe. And a lot of them listen to this conversation. They hear a bunch of demonizing. They feel like they're being treated as a forward operating base for ISIS or a Mexican drug cartel, or that they're going to give nuclear weapons to a country that isn't always friendly with the United States. How do you deal with that perception?
Okay, well, let's distinguish the tribal members who I've met, a number of them, versus the corrupt tribal council government. The tribal council government gets billions of dollars of contracts from the U.S. Department of Defense, among hundreds of millions of other dollars from other U.S. federal agencies. And members of their tribe live in squalor on the reservation. How do they answer that point? Let's talk about the point that they keep their members in poverty while they go live large themselves. Explain how that money gets allocated through the Indian trust accounts. And we all know what the Cobell settlement was, where corrupt tribal governments and councils, were exploited by the Bureau of Indian Affairs and were probably part of it. And as a result, there were $3 billion of settlement that went, $2 billion of which went to purchase reservation lands back for the tribes. That was how the Bureau of Indian Affairs corruption was taken care of. They addressed that way. How do the tribes address their corruption toward their own tribal members? That's the question they should answer to the public. Okay, they don't want to because they don't believe they're accountable.
Okay, let's get to the phones. Catherine, by the way, I need to reiterate that the opinions expressed on the show do not necessarily reflect those of the staff, management, or sponsors of KGVO. Just want to get that out there. So, Catherine, okay. You're on Talkback. Go ahead.
Yeah, good morning. I'm curious. I wanted to kind of ask if there's a way to broaden this a bit. There's the Blackfoot Water Compact and then the Crow Agency Water Compact, which has, Yellowtail Dam is on the Crow Agency. And then there's the Fort Peck Reservation where the reservoir is in the Fort Peck Dam. Has Turkey or any other foreign entity expressed interest in the water rights on those reservation lands? Because those feed into the Mississippi River, which of course is the major water drainage system of the entire United States, and that also feeds the heartlands of America, the food-producing states, et cetera, et cetera. So, is that any part of this, or is this? Am I going too far afield at this point?
No, I think Blackfoot were one of the tribes that were actually invited to Turkey. Okay. So you're not going far afield here. There's obviously reasons why the Turks have certain interests, because there wasn't just the CSKT that was invited.
Okay, we're running short of time. Only got about 3 or 4 minutes.
Right,
So go real quickly. Go ahead, Lawrence.
I would like to make the proposal on the air that this compact and the people of Montana call upon its legislature to re-examine this compact, because the representations that were made by a number of legislators and even by the administration of the state were false, incomplete, and materially and omitting material information that the legislators could have used to make an informed decision to ratify this compact. They didn't have that information. We provided a lot of that information due to our research. And now the people of Montana should be in a position to call, either through a referendum or through other state processes, for the legislature to re-examine this compact with the new information in hand so that they can make an informed decision as of this date. Now, this compact can't be approved by Congress until the Blackfoot Compact itself is approved before it. Okay? This compact also provides that the state and the tribe can opt out if, after 4 years, Congress does not approve it. The people of Montana should look to the Klamath River Basin to instruct its next move, because there they had 3 different agreements that were reached between the state of Oregon, California, and the federal government to close down 4 dams and to provide water rights to the tribes. And guess what? After 4 years of opposition, those compacts or those agreements expired as of January 1 of this year, and those people are somewhat relieved, but the states and the Fed are working together, given their progressive leadership, to somehow piecemeal it back together. But the point is, you have to resist if you're going to protect your rights. If you're going to let them walk over you, then you have to expect the outcome.
Okay, let's get Rena on the line. Rena, thanks for holding. Go ahead. We have about 2 minutes left.
Okay, I just wanted to thank Mr. Kogan for his involvement, because I know quite well he's not doing it for the money. He's doing it to stand up for the property rights of that this country is really built on. And I was there at the state legislature when they had that hearing, and hundreds, people winding down the hall, hundreds of people, most of them tribal members, and they complained about losing their grazing leases, long-standing. If they stood up in opposition, one family even had their children snatched away from them. So the people have done everything they know how to do, but, we're very, very poor here in Montana. And if it wasn't for somebody like Bob Fanning and Mr. Kogan, we'd be up a creek without a paddle.
All right. Thanks, Rena. Appreciate that. I want to get one more call in. Alan, you're on. We got about a minute. Go ahead.
Yeah, good morning. I'm just curious, is the water compact, the Kerr Dam, tied to this Waters of the West EPA action?
Yes, because anything that's a U.S. navigable water would be subject to the waters of the U.S. regulation.
So they're all working
even
together
tributaries
to take
that feed
control
into
of the water.
Go ahead, Alan.
They're all working to take control of our water.
Yes, because out where you are, water's gold.
You bet. Hey, tell you what, we have exactly 1 minute, Lawrence. So how can people get more information on this? Would you mind telling us?
Well, we have a website. Our law firm website is www.koganlawgroup.com, and they can go to the practice page, and at the bottom of the practice page we have all of the legal filings that we have made, both in the U.S. Federal District Court for the District of Columbia, and also we had some administrative filings with the Federal Energy Regulatory Commission over the low-cost block of power that's currently being negotiated in silence behind closed doors between the tribe, the federal government, and the Flathead Joint Board of Control.
Mr. Kogan, we are completely out of time. I want to thank you for your time. We deeply appreciate your being on with us today.
Thank you.
Thank you, sir.